Hello, and welcome back to Legal Eyes. I'm Shannon Gunn Emery. Thanks for joining us again. If you've listened to 2.1, 2.2, now we're into 2.3 of How to Run and Hopefully Win Your IRS, you know why I'm doing this. That original podcast was one of our most popular episodes. And yet, it's from 2022, and now we're into 2024. All those arguments that I mentioned in that first episode still work now, unless, of course, I mentioned that you could argue you didn't get a roadside appeal on a refusal. That argument was repealed, but everything else, good to go. However, as you can imagine, there have been a lot of changes since 2022, in particular because of judicial review. If you listened to the Wild Wild West of judicial review, you'll understand how those cases from the Court of King's Bench have been shaping the law ever since December 2020, when the Safe Roads regime came into being. The original arguments from How to Run and Hopefully Win Your IRS still work, but now we have more. We have Gordy, we have Lawson, we have Lawrence, we have Smith, 1, 2, 3, and Colner. These, my dear listener, are little gems, some of my favorites, and today I'm going to introduce you to all of them. So sit back, get comfy as we go through these cases, which hopefully will become powerful tools in your IRS toolbox. Starting with Gordy. The official citation, so you can look it up on Canly, as you know how to do that, is Gordy, Gordey versus Alberta Director of Safe Roads, 2023 ABKB 228. This is a lovely little decision from Justice Harris. It's not a huge, long read, and it's certainly not boring. I find she writes very interesting decisions. In any event, Mr. Gordy was stopped on November 20th, 2021, and he was given a NAP on the basis of 80 plus. And just a little reminder, when I say 80 plus, I mean it was on the basis that he had operated a motor vehicle with a blood alcohol level at or exceeding 80 milligrams of alcohol in 100 milliliters of blood. And you and I both know I don't want to have to say that every single time when I talk about what the basis of the NAP was. 80 plus. We used to say over 80, but did you notice? The legal limit got lowered. It's at or over 80, hence 80 plus. Now you know. So only basis was 80 plus. Why do I mention that? Because it could have been 80 plus and impaired operation, but it doesn't look like, from Justice Harris's decision in Gordy, that it was. At paragraph 8, Justice Harris starts the story. In the early morning hours of November 20th, 2021, sounds a lot like Once Upon a Time, Corporal Jasicison and Constable Athwal conducted a traffic stop of a vehicle operated by, guess who? You are so good at this. Yes, Mr. Gordy in Grand Prairie, Alberta. Constable Athwal approached the driver's side, and then they decided that Constable Athwal would administer the screening device test, and it registered a fail. Corporal Jasicison then explained that Mr. Gordy could perform a second screening as an appeal, and he said he wanted to. Corporal Jasicison administered the second ASD screen, which registered a fail. So far, so good, right? Not really, because in the end, the only documents, the only report or notes that were sent in were from Constable Athwal. And although Justice Harris said, yes, Constable Jasicison is likely very trustworthy, I should have said it's Corporal. Corporal Jasicison is even more trustworthy than Constable. No, I'm just kidding. Corporal Jasicison is probably trustworthy, but where Constable Athwal is basing some of his grounds on the issuance of the NAP on what another officer said, we are entitled to the notes and the reports of all the officers present. So, takeaway, this is what you have to keep in mind for Gordy. If two or more officers were significantly involved in the investigation, then we should have the notes and reports of both. If the issuing officer is relying on information from somebody else, so I extend that to EMS, civilians, anyone else, where it probably is hearsay and it's on a very important point, we should have had the documents from those other people, those original sources. Moving on to Lawson. And normally I'd spend more time on Gordy, but we have a lot of stuff to cover. Let's go. Lawson, Lausen versus Alberta Director of Safe Roads 2023 ABCA. That means the Court of Appeal, highest court in Alberta. That's a big deal. 176. And this was a big deal. Frankly, Lawson was a game changer. Good job, Catherine Bayak out of Calgary. It was her case, and she did a great job. At paragraph 3, the Court of Appeal explains, early on March 2021, just like that, once upon a time, the appellant was stopped by the RCMP while driving near Strathmore, Alberta. They demanded and obtained a breath sample using an approved screening device. The device registered a fail. They kind of get to the point quickly. I do like that. They arrested the appellant for impaired driving. That becomes an issue in Colner later on that I'm going to talk about, but we're going to leave that aside for now. Police arrested him. They performed a record check. They decided that they were going to proceed only with administrative sanctions. They did not inform the appellant of that decision. Interesting that they make that note. They don't comment on it a lot more, but that does become a big deal in Colner. I love giving out little foreshadowing of what's going to happen. Getting back to our decision about Mr. Lawson. The appellant recounts in an affidavit, a thrilling affidavit, his version of what happened. The officer said he switched the machine so I could provide a sample on a second machine. The officer then told me, blow into the second machine. I agreed and blew into the machine the second time because he told me to, and I thought I had to. I was not told that blowing into the machine the second time is voluntary or that I did not have to do so. The police recorded a different version of events, noting that the appellant was offered the opportunity to provide a second sample on a new instrument and that the appellant indicated he wished to provide a second sample. The appellant was not told the second sample was an appeal, but he was told if he passed the second test, the police would use that result. The second test also returned a fail. The keys to this case were flagged early on by the Court of Appeal in paragraphs 12 and 13. They noted that Section 88.1 sub 5 of the Traffic Safety Act requires the peace officer to advise the driver of their right to voluntarily undergo a roadside appeal. Paragraph 13, they noted that Section 10AI of the Safe Roads Alberta regulation specifically required written notice of the right to a roadside appeal. Section 88.11 sub 2 of the Traffic Safety Act, this is a little like ping pong, I do agree, details how a roadside appeal is to be performed, and it says where the driver requests an appeal and voluntarily attends immediately at a place designated, they can do the test. Back to Safe Roads Alberta regulation. I'm not kidding. In paragraph 15, we bounce back to section 4 of the Safe Roads Alberta regulation, which specifies that one of the grounds for cancellation of a penalty is that the officer did not advise the recipient in writing of the right to a roadside appeal, and the recipient was unaware of that right. That last part is important. Even if the police didn't give the person the roadside appeal information in writing, if the applicant was otherwise aware or made aware of that right, then there is no issue, potentially. The adjudicator in Lawson figured that the timing of the paperwork and when it was given to the appellant really wasn't a big deal. The Court of Appeal begged to differ. The Court of Appeal said, there's no utility in advising a driver in writing of the right to a roadside appeal or in requiring awareness of that right only after the appeal has been administered. On a plain reading of Section 4 EV, this is all from paragraph 46 if you want to look it up, the apparent purpose of requiring at least written notice or awareness must be so that the driver has the information necessary to determine whether to request a roadside appeal. Such notice or awareness must necessarily come before the driver declines or agrees to the second test or further assessment. This understanding is consistent with the word right, which connotes an entitlement that one may choose to exercise. That is pretty powerful stuff. But they didn't stop there. Paragraph 50, they said, it's apparent from a number of provisions that the statutory scheme requires written notice before the roadside appeal. Section 88.11 sub 2 of the TSA, there we are back in the TSA again, Traffic Safety Act, provides that a roadside appeal is to be conducted notwithstanding that a notice of administrative penalty has been issued where a driver requests an appeal of that notice of administrative penalty. It explains that the applicable roadside appeal test or assessment depends on what the basis for issuing the notice of administrative penalty was. It is significant that the NAB is referenced using the past tense. Takeaway from Lawson is police officers should be going in this order. They get the fail. They issue the notice of administrative penalty so that someone knows there is an immediate roadside sanction. They know that they're facing an immediate suspension of their license, immediate impoundment of the vehicle. They know that they are being now given in writing the opportunity to blow into a different device, which will either confirm or cancel the original penalty. And, in my opinion, they should be told, but this is not completely outlined in Lawson, that there's no downside to doing the roadside appeal. The situation can't get worse. It could only get better. There's nothing worse than a fail. But if they get a caution or they blow under, then the police have to use the lower of the readings. We can use Lawson to argue that the driver should have been served the paperwork about the IRS before they're asked to do the roadside appeal. Now, if the person who is the subject of the roadside appeal already knew about it or the officers explained it really, really well, see Vandermeulen, you can look that up yourself, then maybe there's not an issue. This argument often depends on the right set of facts. It's context specific. But Lawson says that's how it's supposed to be done. And a really fun twist is that almost immediately after Lawson, the director of Safe Roads made a special application of the Court of Appeal. They asked the court to reconsider its decision in Lawson. All the crazy details are there for your reading pleasure. The case is called Lawrence, Lawrence versus Alberta Director of Safe Roads, 2023, ABCA 271. If one ever needed proof that the Director of Safe Roads was really, really mad that they lost Lawson, you have to read Lawrence. Just so you know, applications to have an appeal court reconsider one of its prior decisions are really rare. I mean, think about it. You're asking the highest level of court in Alberta to declare in a written decision that they really screwed up their prior decision. They got it all wrong. You can imagine how often those kinds of applications are successful. Okay, I have to share this with you. I won one of those cases, and it's such an interesting set of facts. The case was called Weaver, WEAVER 2005 ABCA 105. We were asking the court to reconsider its prior decision in a case called Cutforth, CUTFORTH. You can look it up. But the reason why this case stands out for me is its karmic quality. You see, my father was the defense counsel in Cutforth, and he was also the defense counsel in Weaver. At trial, that is. On appeal, it was his daughter. The trial judge was the same in both cases, too. 18 years later, after my dad and that judge had tried to improve the law with respect to detentions in impaired driving cases, the court agreed that the two of them, Bruce Gunn and Judge Rolfe, had got it right. I believe the Weaver decision may be the last Court of Appeal decision where my father was named as defense counsel because in 2006, the following year, he passed away. Okay, enough about the anecdote concerning a successful application to have the court reconsider one of its cases. Instead, let's go back to Lawrence. Yeah, a bit of foreshadowing there. Lawson had been decided June 6th, 2023. Lawrence was decided by the Court of Appeal pretty much 3.5 months later, September 27th, 2023. So literally they're saying to the court, we think that 3 months ago, you got it wrong. Things have changed so much in the last 3 months and you got it wrong. You know, the Court of Appeal doesn't like being told that they're wrong. And it is not very surprising that the Court of Appeal said, no, we actually meant what we said in Lawson. They did soften Lawson a tiny bit because in Lawson, the court had said it would be impossible to have that awareness of the roadside appeal without first being given either the notice of administrative penalty or the roadside appeal information in written form before being asked about the roadside appeal. They said it could be coming from some other source. That's sort of what they said. But they reinforced what was most important. And now we have 2 Court of Appeal decisions that say that this is how things are supposed to go. Check out paragraph 22 of Lawrence. The Court of Appeal said, the decision in Lawson sets out a practical, reasonable procedure for issuance of a notice of administrative penalty to a suspected impaired driver. A. The driver blows into the approved screening device. B. If the device registers a fail, the officer provides the driver with the notice of administrative penalty and tear-off sheet indicating a voluntary right to a roadside appeal. C. The officer confirms the driver is aware of the right to a roadside appeal and wishes to provide a second breath sample. I do like C because even though you've got B, what if the person's illiterate? What if they don't speak English very well? What if it's a youth? What if that person is a little slow or is having a panic attack? You really want to make sure that person actually understands the right. And then D, if the driver so requests, they may blow into a second approved screening device, and if they again register a fail, the notice of administrative penalty remains in place, subject to adjudicative review. The problem in Lawson was that step D occurred before steps B and C, and the driver testified that he was told to blow into the second machine and not told that blowing into the machine the second time was voluntary. On those facts, says the Court of Appeal, it was a reasonable conclusion that at the time of the second blow, the driver was unaware of his right to appeal the notice of administrative penalty. He was merely told to blow a second time, and he did. So, the Safe Roads adjudicator in Lawson, who said, timing of the service of the paperwork, not important. So wrong. Moving on to SMIT 1, SMIT 2, SMIT 3. Yes, there are 3 SMIT decisions. SMIT 1 is SMIT and Alberta Director of Safe Roads 2023 ABKB 435. All of the ones I'm going to talk about today are by Justice Whitling. In SMIT 1, Justice Whitling said, we are all entitled to the audio and video recordings when stopped by police if they generated any. You would think that that would be very evident. Like, isn't that the best evidence one could have? Isn't that the most convincing evidence of either impairment or lack thereof? Yeah, I know. It makes perfect sense. But we weren't getting them. And then SMIT 1 was decided and whoof, we got avalanches of audio and video recordings and it was fantastic. And then a few months later, the government came out with an amendment to the Safe Roads Alberta Regulation 2.1 that said audio and video recordings, not required records. But it was temporally limited. It was limited until August 31st, 2025. But that was mainly because I wouldn't consent to staying the decision while it was under appeal in the Court of Appeal. Then, just recently, as of about 2.5 weeks ago, as of when I'm doing this podcast, the director abandoned their appeal in the Court of Appeal. And now I'm curious about what will happen with that amendment. if you want the audio and video recordings, you should be asking for them, and you should be citing Smith and Alberta Director of Safe Roads 2023 ABKB 435. Smith number 2 is when the director brought an application to strike or modify most of Smith 1. Remind you of Lawrence? Silly director. Anyway, that didn't work out. They were shot down in flames literally the next day. Justice Whitling filed his decision. Didn't take him long to figure out that one. Moving on to Smith number 3. The citation for Smith 3 is Smith versus Alberta Director of Safe Roads 2024 ABKB 192. Now this one takes a bit to get through, and it's not the easiest. So I am just going to summarize it for you. Justice Whitling says that everything pretty much that happens at the roadside during screening for impairment is a time when the right to counsel is suspended. Everything has to go quickly, both the initial test and the roadside appeal. There is, therefore, no reasonable opportunity to contact counsel. I don't agree with him on that, but that's what he said. And so right to counsel is suspended. However, in Ms. Smith's case, all of that happened quite rapidly, 13.5 minutes. The rest of the, I think it's 45 minutes that she spent in the back of the police vehicle, she was detained and not given a right to counsel, and the right to counsel was not suspended at that point. And so there are 2 big takeaways from Smith 3. 1, right to counsel is still a thing that police have to consider even when there is an administrative regime in place like Safe Roads. Believe it or not, police seem to treat it like, oh, we get to just completely ignore the provisions of the charter. It's a charter-free time. As soon as we utter the words Safe Roads, we are safe from the charter. No, he said no, and he was going to give police time to consider how to apply his decision properly. I loved that. The reason why I'm now moving on to Kolner is because, as you will see, Kolner dots the I and crosses the T of Smith. It just completes it. Kolner, Kolner, and Alberta Director of Safe Roads 2024 ABKB 456. Look it up. Delightful read from Justice Spoken For. I would suggest you start at paragraph 20. What Justice Spoken For wrote was this. During any traffic stop, the driver of a motor vehicle is detained. Detention triggers the right to counsel as guaranteed by Charter Section 10B. Yes, it does. However, in a criminal impaired driving investigation, the right to counsel is not absolute. It is suspended during the roadside screening process. A police officer has lawful authority to ask a driver about their alcohol consumption, make a demand for a breath sample, and obtain a breath sample into an ASD pursuant to Criminal Code Section 320.27 without first informing the driver of their right to counsel. It is not correct to refer to the roadside suspension of the right to counsel as the absence of the right to counsel. You are so right, Justice Spoken For. Thank you. Rather, the right to counsel is suspended during the roadside screening process up to and including the breath sample into an ASD. The roadside screening process includes screening measures preceding the breath demand and during the driver's compliance with that demand. See Smith 10B at paras 26-250. Smith is a long read. All the Smiths are a long read. To be clear, though, the Smith that Justice Spoken For is referring to in that passage of Kolner is Smith 3. She comments on Smith 10B, as she calls it, at paragraph 24. Justice Spoken For wrote, in Smith 10B, the court found that the implicit suspension of the right to counsel is effected during a TSA administrative investigation, which includes the period before the initial breath sample demand and during compliance with that demand. This finding is consistent with the jurisprudence in British Columbia, and she cites a few cases. The court in Smith 10B also found that the implicit suspension includes the period during which the driver must decide whether to request an appeal test. She looks at, in her case, how things went for Mr. Kolner. And she says at paragraph 25, in this matter, the officer chose to pursue both the criminal and administrative paths. Remember how I said in Lawson that it was really important that the Court of Appeals said he was arrested? And then, when the police decided to go purely administratively, they did not inform Mr. Lawson of that. Those words are coming back here. After the fail, on the screening device, the officer arrested Mr. Kolner, advised him of his right to counsel, and cautioned him about his right to remain silent, using wording on the Calgary Police Service charter card. Mr. Kolner said yes, he wanted to call a lawyer, but the officer took no steps to facilitate an opportunity for the applicant to contact counsel. Instead, the officer immediately advised the applicant that he had a right to take a second test. I love that. Please imagine that you are the person in the back of the police vehicle. You've blown into a screening device. You failed it. You're handcuffed. You're being told that you are being charged. You're being charged criminally for impaired operation of a motor vehicle. They give you your right to counsel. Do you want to call a lawyer? You say, yes, please. And then they go, okay, we're just going to ignore that. They've already told you, we're going to give you access to telephone and telephone books, and you can call any lawyer you wish, or free counsel from Duty Counsel for free, immediate legal advice. Do you wish to call a lawyer? Yes, I do. Great. So we've registered that answer, but we're moving on now. We don't have to actually do anything we just told you. Talk about bringing the administration of justice into disrepute. What could be worse? Finally, with Kolner, that ends. If the officer, she says, that was at paragraph 25. Paragraph 26, if the officer had proceeded with the criminal investigation only, the officer would have made an evidentiary demand for breath samples. That means samples of breath at the station. They would have taken Mr. Kolner back to the station. He would have blown into the Intox ECIR2. That would have given real readings, etc. And the officer would have been required to provide the applicant with an opportunity to contact counsel before obtaining from the applicant any evidentiary breath samples on an approved instrument. Now she goes on to say at paragraph 27, if the officer had proceeded with an administrative investigation only, after the ASD fail result from the initial breath test, the officer would have advised the applicant of his right to an appeal test. The right to counsel would have been suspended as per SMIT 10B because all of that has to be immediate. But the suspension of the right to counsel would last only if the steps necessary for the appeal test were performed without delay. Following this reasoning in SMIT 10B, the timing of the steps would have been important in assessing whether the right to counsel remained suspended if the officer had proceeded with an administrative investigation only. The question would be whether the applicant had sufficient time to contact and consult with counsel. By the way, Justice Whitling in SMIT 3 said 7 minutes is enough. So if there's a gap of 7 minutes or more in your case, that's ample time to contact counsel and retain counsel and get legal advice. Frankly, if you call the legal aid hotline that the police often shove down your throat as the option to call at 2 o'clock in the morning, the call is 2 to 3 minutes, almost never more than 5. So 7 minutes, ample time. Takeaway from Kolner is if there is a parallel investigation, if they're doing criminal charges and they're also going the safe roads route at the same time, then they have to be very careful. Justice Bokenfor at paragraph 30 said, while the criminal investigation was ongoing, the officer was required to facilitate an opportunity for the applicant to contact counsel. However, it was open to the officer to abandon the criminal investigation and proceed only with an administrative investigation. The Crown argues that is what occurred. But at the end of the day, the problem is that there was nothing in the officer's notes or in the rest of the record to suggest that the officer made a subjective decision to abandon the criminal investigation and proceed solely with the administrative investigation, nor did he ever indicate that the applicant was no longer under arrest and was free to leave. At paragraph 35, Justice Bokenfor said that she found that the applicant's Charter Section 10B right was breached, the officer needed to advise the applicant that the criminal investigation was concluded and advise the applicant that he was only proceeding with an administrative investigation, and that would have provided transparency with respect to the investigation being conducted and would ensure that drivers are aware of their jeopardy and of their rights and obligations. She says at paragraph 35, the Safe Roads legislative regime and forms are structured so that drivers are aware of their jeopardy under the Traffic Safety Act and their right to an appeal test. The regime and the forms show an objective that is consistent with the purpose of the Charter's Section 10B, which guarantees that detainees understand their legal situation and can make informed decisions related thereto. She doesn't say that an officer can't conduct both, but she cites Woodworth and Alberta, Director of Safe Roads, another great read, 2023 ABKB 468 at paragraph 25, about how important it is that both the officer and the driver understand where they're at in the investigation. The right to counsel, she said, at paragraph 37, might not be suspended at one point in time during a criminal investigation, but be suspended at the same point in time during an administrative investigation. In other words, the officers have to think about right to counsel. Now, she ended up giving only a declaration as the remedy because she said the adjudicator at the time, those were very early days, pre-SMIT 1, 2, and 3, was entitled to think on the basis of a case called Rose that maybe Charter didn't really apply in this regime. But Justice Bokenforth said, now with Kolner and SMIT 1, 2, and 3, and Curtis, as well as a number of other decisions like Woodworth, there is no suggestion now that the right to counsel just doesn't ever apply in this context. It may apply. So, takeaway from Kolner, if at some point you were arrested, you were handcuffed, you were read your rights, rely on Kolner. You should have been given your right to counsel. And did the police at any point make it super clear, abundantly clear, that they were no longer continuing with the criminal investigation? They were only going provincial sanction, administrative sanction, Safe Roads regime, whatever they want to call it. Did they make that clear? If they didn't, you may have a good argument, my friends. Thank you for joining me today. That is just a sampler of some of the great cases that have come out through judicial review in the last few years and which have been changing the legal landscape for IRSs. Don't believe anyone if they tell you you can never win these. Not true at all. Shannon Gunn Emery, signing off.